Hello students, myself Bafna ma'am. Now next video we will be taking about doctrine of caveat emptor. Now what do you mean by caveat emptor? Caveat emptor means buyer be aware. यानी buyer beware. जो buyer है उसको aware रहना है whatever he is buying, which means that the buyer is want to protect his interest. According to this principle, a buyer should be careful while purchasing goods suitable for his own purpose. See, if the buyer has not made any inquiry regarding goods, the seller is not under any obligation to disclose every defect in the goods of which he may be aware. So, the buyer should thoroughly examine the goods and he should also see that goods which he purchases are suitable for the purpose for which he wanted them. Therefore, if the goods fail to satisfy the requirement of the buyer, he cannot hold responsible the seller. The reason is that no implied condition or warranty as to the quality or fitness of any particular purpose of goods is supplied under a contract of sale. Further, there is increase in the variety of the goods and the extensiveness of it. It has become difficult for a buyer to inspect each and every kind of goods and confirm that such goods will satisfy his requirement. So the principle of caveat emptor is getting gradually diluted. See here, if a buyer communicates to seller the type of the goods he wants to purchase and relies totally on the skill and judgment of the seller, then the seller is under the obligation to supply the goods which is suitable for the purpose of the buyer. So therefore the Sale of Goods Act provides exception to the doctrine of caveat emptor. यानी caveat emptor ये है कि buyer should be aware of whatever he is purchasing. So for his own purpose he should be aware, and while purchasing he should keep in his mind whatever the defects is there, it should be known by himself. There is no obligation on the seller that if any defect is there that he will tell. And if he has purchased the goods and after that if he found any defect, seller will not be held responsible for that. So there is caveat emptor for the buyer. It is called buyer beware. And in certain exception, caveat emptor does not apply. There are certain exceptions. If buyer relies totally on the seller of the skill and judgment of the seller, then the seller will be held responsible. Buyer will not be held responsible. Certain exceptions are there. We will see what are those exceptions. The rule of caveat emptor. Misrepresentation by the seller. See, where the seller makes a misrepresentation and the buyer relies on it, the rule of caveat emptor does not apply, since such contract is voidable at the option of innocent party, that is the buyer. Here the buyer can cancel the contract. First is that. Second is concealment of the latent defect. Latent defect means defect which cannot be discovered on a reasonable examination. If the seller intentionally deals or does not disclose the latent or hidden defect in the goods, the rule of caveat emptor does not apply. Okay. Third is fraud by the seller. If the seller makes a false representation which points to fraud and the buyer relies on it, the rule of caveat emptor does not apply. So the contract is also voidable at the option of the buyer. And hence, if he gets a right to claim damages for the fraud, so he can claim the right he can claim the right for the damages. Fourth is sale by description. See, where the goods are sold by the description and the goods supplied by the seller do not correspond with the description, the rule of caveat emptor again does not apply according to section 15. Fifth is sale by sample. If the goods are sold by sample and the goods supplied do not correspond with the sample, the rule of caveat emptor does not apply. Section 17. Sale by sample as well as by description. Where the goods are sold by sample as well as by description and the goods supplied by the seller do not correspond with both sample and description, the rule of caveat emptor again does not apply. Okay. Now we will see seventh point is fitness for a particular purpose. See, where the buyer makes known to the seller, see if the buyer tells to the seller the purpose for which he wanted to purchase the goods and relies totally upon the seller's skills and judgment. In such case, when the goods supplied are found to be unfit for the buyer's specified purpose, the rule of caveat emptor does not apply. Here the seller is liable to pay the damages for the same. Okay, fitness for a particular purpose. Merchantable quality. Where the goods are purchased by description from the seller, who usually deals in those goods or goods of that description, and the goods sold by the seller turn out of merchantable quality, the rule of caveat emptor does not apply. The buyer in this case has a right to recover damages for the loss suffered. Here we can see the example here. If a bottle of a cold drink get broken while in the act of uncrooking it, then one can say that the bottle is not of merchantable quality. Okay, the quality matters a lot here. Trade and usage. If the trade and usage attaches an implied condition and warranty as to quality or fitness and the seller deviates from that, the rule of caveat emptor does not apply. The seller is therefore liable to pay the compensation. Okay, so we have seen certain exceptions of the rule of the caveat emptor. So misrepresentation by the seller, if there is any defect, if there is a fraud conducted by the seller, if the goods are not according to the sample and descriptions, there is no fitness in the goods or the purpose for which the buyer had relied upon the sellers, and there is if the goods quality is not of merchantable quality and trade and usage, so the seller will be held liable. These are the exceptions of the caveat emptor. Now we will see next we will deal with the transfer of title by non-owners. See, you can transfer the title. When a seller transfers the title to the buyer, he has the ownership. Seller is having the ownership and he transfers the ownership to the buyer. Now in certain cases, when seller do not have the ownership, and in that case if he transfer to the buyer, will the buyer get the ownership or not? We will see in the next chapter here. So transfer of title by non-owner. What is transfer of title by non-owner? Where ownership of the good is to be transferred from the seller to the buyer. अभी seller और buyer है, यहाँ पे ownership goods का जो goods है उसकी ownership transfer हो रही है seller से buyer. It is presumed that a seller is an absolute owner of the goods, and the transfer of the ownership, and on the transfer of the ownership, buyer also becomes an absolute owner of the goods. But if the seller is not the absolute owner of the goods, the buyer will not get an absolute ownership of the goods. In other words, the buyer will not get better title than what the seller himself has. So a person who is not the owner of the goods cannot therefore make the other person owner of those goods by selling them to him. Therefore, the general rule is transfer of title on sale is that the seller cannot transfer to the buyer of goods a better title than he himself has. So there is a rule here. It is expressed by a maxim, that is nemo dat quod non habet. Again I will repeat, nemo dat quad non-habet, which means no one can give what he has. That is, one can convey a better title than he himself has. See, the true owner of the goods, and such rule is necessary in the general interest of the public. Therefore, if a thief sells stolen property, the buyer will not get the title of such goods, though he may have purchased the goods bona fide for the price. Still, the true owner of the goods has the right to recover the possession of the goods without paying anything to the buyer. अभी जो चोर है उसके पास ओनरशिप नहीं है, उसके पास टाइटल नहीं है, ओनरशिप का टाइटल नहीं है, बट उसने किसी को बेचा है अपना गुड्स. जो रियल ओनर है वो आके बायर से वो गुड्स लेके जा सकता है उधर से विदाउट पेइंग एनीथिंग. So hence, buyer cannot acquire a good title to the goods unless he buys the goods from a person who is absolute owner of the goods. So यहाँ पे नीट एंड क्लीन से बोला है कि बायर के पास ओनरशिप का टाइटल नहीं मिलेगा जब तक उसने वो गुड्स रियल ओनर से नहीं लिया है. So he does not have any authority to sell the goods. This rule of nemo dat quod non habet is incorporated in section 27 of the Sale of Goods Act, which says that where goods are sold by a person who is not the owner of such goods and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had. The rule has certain exceptions. See, whatever the things concern, whatever the concept is there, whatever the doctrine or whatever the title is given, there are certain exceptions to the rule. अभी यहाँ पे ये बोला है सेलर और बायर. जो सेलर है रियल ओनर है वो ही ट्रांसफ़र कर सकता है ओनरशिप बायर को, और बायर एक बार गुड्स खरीदने के बाद ही बिकम्स एन एब्सोल्यूट ओनर. But in certain cases, certain exceptions are there. Now we will see what are the exceptions here. We will see the exceptions here. The above rule here is no one can transfer a better title than he himself has. It means in exceptional case only, although a person is not the owner of the goods. यहाँ पे ये बोला गया है नो वन कैन ट्रांसफर ए बेटर टाइटल दैन ही हिमसेल्फ हैज़. अभी सेलर के पास तो खुद का ओनरशिप का टाइटल है, वो खुद ही ट्रांसफ़र कर सकता है एक बायर को. बट अभी सर्टन एक्सेप्शनल केसेस भी है जो ओनर नहीं है बट ओनरशिप ट्रांसफ़र कर सकता है बायर को. तो फर्स्ट ए है पॉइंट है एन अनऑथोराइज्ड सेल बाय ए मर्केंटाइल एजेंट. सी एज ए जनरल रूल क्या है, ए एजेंट हैविंग एन अथॉरिटी टू सेल द गुड कैन ट्रांसफर ए गुड टाइटल टू द बायर. He can transfer, that is mercantile agent can transfer a good title to the buyer, that is ownership to the buyer. See, however, a mercantile agent can transfer a good title to the buyer even though he sells the goods without having authority from the principal. यहाँ पे एजेंट के पास अथॉरिटी नहीं है प्रिंसिपल की यानी ओनर की टू डू सो, प्रोवाइडेड दैट फॉलोइंग कंडीशंस आर फुलफिल्ड. उसमें भी कुछ कंडीशंस है जो एजेंट आके खुद का गुड्स यानी माल बेच सकता है विदाउट अथॉरिटी ऑफ द ओनर. ओनर की अथॉरिटी के बगैर वो माल बेच सकता है, पण उसके भी कुछ कंडीशंस है जो फुलफिल होने चाहिए. तो वो फुलफिल होने पर जो एजेंट है वो माल बेच सकता है. यहाँ पे मर्केंटाइल एजेंट मस्ट बी इन पोजीशन ऑफ द गुड्स, यानी एजेंट के पास गुड्स होना चाहिए और डॉक्यूमेंट्स होना चाहिए, टाइटल के डॉक्यूमेंट्स होना चाहिए, गुड्स के डॉक्यूमेंट्स ऑफ द टाइटल टू द गुड्स इन हिज कैपेसिटी एज ए मर्केंटाइल एजेंट एंड विद द कंसेंट ऑफ द ओनर. कंसेंट होना चाहिए कि मैं ये गुड्स में बेच सकता हूँ मार्केट में. सेकेंड पॉइंट है कंडीशंस क्या फुलफिल होनी चाहिए, एजेंट कब अपना माल बेच सकता है. ही कैन सेल द गुड्स वाइल एक्टिंग इन द ऑर्डिनरी कोर्स ऑफ बिजनेस. जब वो बिजनेस करता है तभी उस ऑर्डिनरी कोर्स ऑफ बिजनेस टाइम में वो गुड्स बेच सकता है, यानी माल अपना बेच सकता है. द बायर शुड एक्ट इन अ गुड फेथ. यहाँ पे क्या बोला है, बायर के लिए बोला है. ही शुड एक्ट इन अ गुड फेथ एंड विदाउट हैविंग एनी नोटिस एट द टाइम ऑफ कॉन्ट्रैक्ट. बायर को मालूम नहीं होना चाहिए जब कॉन्ट्रैक्ट कर रहा है, जब माल ले रहा है, दैट द एजेंट हैज़ नो अथॉरिटी. बायर को मालूम होना नहीं चाहिए कि भाई एजेंट के पास वो अथॉरिटी नहीं है माल बेचने की. तो उस हिसाब से एक्सेप्शंस टू द रूल विल अप्लाई. नाउ वी विल सी एन एग्जांपल हियर. P gave his car to his agent Q for selling same for not below rupees 1 lakh. However, Q sold the car to R for rupees 75,000. R, acting in good faith and without knowing the fact that Q was not authorized to sell the car for not less than rupees 1 lakh, gets a good title to the car, and the true owner P cannot recover the car from R. Okay, so here the buyer has got the good title after taking the car. The cost of the car is 75,000. Though he did not have an authority to sell, but he got a good title here. So unauthorized sale by a mercantile agent. The second point we will see here is transfer of title by estoppel. The rule of estoppel prohibits a person from making any contrary statement to his earlier statement. कभी किसी ने अर्लियर स्टेटमेंट दिया है तो उसके विपरीत कुछ स्टेटमेंट और देना नहीं है. द रूल ऑफ एस्टोपल प्रोहिबिट्स ए पर्सन. यहाँ पे प्रोहिबिट कर रहा है पर्सन को. सी व्हेन इट अराइजेस व्हेन वन इज प्रिक्लूडेड फ्रॉम डिनेइंग द ट्रूथ ऑफ एनीथिंग विच वन हैज रिप्रेजेंटेड एज अ फैक्ट ऑल्दो इट इज नॉट अ फैक्ट. नाउ वी विल सी हियर द एग्जाम्पल. By the example, we will come to know the clarity of the picture. P in the presence of Q, Q is a real owner here, tells R that P is the owner of the washing machine and sells it to the R. Here R will get a absolute ownership of washing machine even though P had no title to it. P के पास title नहीं था. This is so since Q remained silent. Q तो silent ही था at the time of deal. Though he was the real owner. Q real owner था पर P ने क्या कहा कि मैं ओनर हूँ और आप वॉशिंग मशीन ले सकते हैं. R को बोला तो R को एब्सोल्यूट ओनरशिप मिला. So therefore Q by his own conduct is prohibited. Q उसके कंडक्ट से ही prohibited, stopped. वो डिने नहीं कर सकता है अभी पीस अथॉरिटी टू सेल वॉशिंग मशीन. अभी क्यों डिने नहीं कर सकता है पी को कि भाई आप वॉशिंग मशीन नहीं बेच सकते हैं, क्योंकि एट द टाइम ऑफ सेलिंग क्यू रिमेन साइलेंट. सी व्हेन द रियल ओनर ऑफ द गुड्स बाय हिज कंडक्ट और वर्ड्स लीड्स द बायर टू बिलीव दैट द सेलर इज द ओनर ऑफ द गुड्स और हैज अथॉरिटी टू सेल देम, he cannot afterwards deny the seller's authority to sell. यहाँ पे seller's authority to sell कौन है? P. In such a case the buyer gets a better title. Buyer को better title मिला है than that of the seller. Okay? Transfer of title by estoppel. So Q here in the example, Q is being denied. He is being prohibited. By his own conduct it is been prohibited, it is been stopped from denying P's authority to sell the washing machine. Okay. Now third point here we will see here is sale by one of the joint owners. If a buyer purchases goods in the good faith from one of the several joint owners, इतने सारे joint owners से उसमें से एक ओनर आके कुछ माल बेचता है एंड बायर उस गुड्स को परचेस करता है, उस माल को परचेस करता है, who is in the sole possession of them with the permission of the other co-owner, the buyer will get a good title to the goods. Okay, Here, again I will tell this. If a buyer purchases goods in the good faith from one of the several joint owners who is in the sole possession of them with the permission of the other co-owner, he is taking the permission of the other co-owner and selling the goods, the buyer will get a good title to the goods, provided that at the time of contract of sale, he had no notice that the seller had no authority to sell. The buyer should come to know. Here, the buyer will get a good title when he will get a good title at the time of the contract. He did not notice that the seller had no authority to sell. He was not knowing that this seller has no authority. Again, the co-owner of the goods has a limited ownership in it. But under this exception, he can transfer the total ownership in the goods to the buyer. See, we will see here example here is P and Q jointly purchased a set of textbook of TY bcom class, and it was decided that Q would keep the books with him till the results of bcom classes are out. Q sells the books, the whole set he sells to R. R was not aware that Q did not have any authority to sell. So in the given case, R would get a good title to the whole set of textbook. See, sale by one of the joint owners, so the buyer is getting a good title, though he had no notice that the seller had no authority to sell. Okay? So this is another exception. The fourth exception we will see here is fourth, sale by a person in possession under a voidable contract. We have already seen that in a contract, if the consent of the contracting party is obtained by, यानी कंसेंट मिला है, जो कॉन्ट्रैक्टिंग पार्टी है उसका कंसेंट कैसे मिला है, बाय कोर्शन, अनड्यू इन्फ्लुएंस, फ्रॉड, मिसरिप्रेजेंटेशन, द कॉन्ट्रैक्ट बिकम्स वॉइडेबल एट द ऑप्शन ऑफ सच पार्टी हुज कंसेंट वाज सो ऑब्टेन्ड. अभी कॉन्ट्रैक्ट यहाँ पे वॉइडेबल हो सकता है अगर आपने कंसेंट उस कॉन्ट्रैक्टिंग पार्टी से कैसे लिया है, कोर्शन, अनड्यू इन्फ्लुएंस, फ्रॉड, मिसरिप्रेजेंटेशन, यानी डरा धमका के, बेला फुसला के, फ्रॉड से मिसरिप्रेजेंटेशन किया है यहाँ पे, तो वो कॉन्ट्रैक्ट वॉइडेबल है और किसने ऐसा कंसेंट दिया है वो अवॉइड कर सकता है. So the party whose consent was not free due to the above mentioned clause has a right to rescind the contract. यानी वो contract cancel कर सकता है. Hence, if a person has obtained the possession of the goods under a voidable contract and he sells those goods before the contract has been rescinded, अभी contract तो voidable है, उसने goods भी ले लिया डरा धमका के, आगे उस कॉन्ट्रैक्ट को तोड़ने के पहले ही उस गुड्स को बेच दिया, यानी माल को बेच दिया, तो बायर ऑफ सच गुड्स गेट ए गुड टाइटल टू देम प्रोवाइडेड दैट द बायर एक्ट्स इन अ गुड फेथ and without the notice of seller's defective title. Here you have to see every line it is been told in this here in this book is here. The buyer acts in good faith. Buyer acts in good faith without the notice of seller's defective title. This line should be included in every exception. Okay, so we will see here one of the example here is P threatens Q to kill him if Q does not sell his Toyota Fortune car to him. P for 10,000. Q sell his car to P at the set price. This is a voidable contract as Q's consent is not free. Because it is obtained by coercion, he can avoid the contract. But before Q avoids the contract, P sells the same car to R for rupees 2 lakh. So R does not know that the Q's consent was not free. Here R would get a good title to the said car. Okay, the clarity of example is very nice here. So the next exception to the non-owner here is sale by a seller in possession of a goods after sale. अब तो माल तो बिक गया है, पोजेशन आपके पास है, सेलर के पास पोजेशन तो है, लेकिन बायर पैसा दे के गया है, बाद में माल लेके जाएगा. तो अभी इसमें एक्सेप्शंस में क्या लिखा है, व्हेन ए सेलर आफ्टर हैविंग सोल्ड द गुड्स कंटिन्यूज टू बी इन पोजिशन ऑफ द गुड्स और ऑफ द डॉक्यूमेंट्स ऑफ द टाइटल टू देम एंड अगेन सेल्स दीज गुड्स टू अनदर पर्सन, अगर फिर से वो ही गुड्स जो पोजीशन जो माल उसके पास पड़ा है दूसरे लोग को बेच दिया है, अगर सेकेंड बायर को बेच दिया है, तो द सेकेंड बायर गेट्स ए गुड टाइटल, यानी उसको ओनरशिप मिलती है सेकेंड बायर को, प्रोवाइडेड दैट द सेलर इज इन पोजीशन ऑफ द गुड्स। प्रोवाइडेड क्या है, सेलर के पास गुड्स होना चाहिए as a seller and the second buyer act in the good faith. Again here, if the second buyer acts in a good faith and does not have a notice of previous sale, यहाँ पे बायर को मालूम नहीं है कि सेलर ने ऑलरेडी माल बेच दिया है, तो there is an exception here. Another exception is sale by a seller in possession of goods after sale, so the buyer will get a good title here. Okay, now sixth exception is here is sale by a buyer in possession. See, where a buyer has agreed to buy the goods and has obtained possession of the same or of a document of title to the same with the consent of the seller and sells the goods to another person who acts in good faith. Again see here, again the person who acts in good faith and without the notice of any lien or other right of the original seller in the respect of those goods, he gets a good title of the goods. Okay, so here the buyer will get, these exceptions are here, the buyer will get a good title to the goods. Now we will see the seventh exceptions. We will see here example here. P agrees to sell his Parker pen to Q after a month, but P hands over the possession of the said pen to Q immediately and Q sells the pen to R the next day. R in this case would get a good title to the goods because he acts in good faith. He is acting in a good faith. यहाँ पे क्या बोला था, पार्कर पेन 1 महीने के बाद मिलेगा, बट अगले दिन ही दे दिया उसने, इमीडिएटली दे दिया और इमीडिएटली देते ही उसने आगे बेच दिया. So here the R is getting a good title because he was not knowing. He gets a good title to the goods because he acts in a good faith. Here R is acting in a good faith. Okay. Now we will see the seventh exception is resale of the goods by an unpaid seller. अनपेड सेलर यानी सेलर को पे नहीं किया है, उसके पहले ही रीसेल हो गया है. सो वेयर एन अनपेड सेलर आफ्टर एक्सरसाइजिंग हिज राइट्स ऑफ लीन और स्टॉपेज ऑफ गुड्स इन ट्रांजिट अगेन एक्वायर्ड द पोजीशन ऑफ द गुड्स. यहाँ पे जो अनपेड सेलर है, जो सेलर को पे नहीं किया है, he is exercising the right of lien यानी retaining of the goods, और जो goods ट्रांजिट में है उसको स्टॉप किया गया है, आगे माल नहीं बेचे, आगे जाने नहीं दे. अगेन acquired the possession of the goods, फिर वो पोजेशन लेता है goods को सेलर. can resell those goods although the ownership in the goods has been already passed to the buyer and the second buyer gets a good title. अगर फिर से उसने रीसेल किया है सेकेंड बायर को, तो दैट सेकेंड बायर विल गेट ए गुड टाइटल टू द गुड्स एज अगेंस्ट द ओरिजिनल बायर. जो दूसरा रीसेल किया है सेकेंड बायर, इफ ही इज एक्टिंग इन अ गुड फेथ, he will get a good title, he will get a ownership. तो माल की ओनरशिप मिल्कियत उसको मिलती है, ना कि ओरिजिनल बायर को. ओके. नाउ एट्थ एक्सेप्शन हियर इज a sale by a finder of goods. See, if a finder of a goods can sell the goods which he has found, अगर किसी का goods गुम गया है और फिर वो फिर सेल करता है, उसको मिलने के बाद अगर किसी इंसान को गुड्स मिला है और फिर वो सेल करता है, इफ द ओनर ऑफ द गुड्स कैन नॉट बी फाउंड विद द रीजनेबल डिलीजेंसी और इफ ही refuses अपॉन द डिमांड टू पे द लॉफुल चार्जेस ऑफ द फाइंडर, The finder can sell the goods if they are perishable nature. अगर किसी इंसान को goods मिला है, अगर वो पेरिशेबल नेचर का है और पूरे ढूंढने की कोशिश की है, लॉफुल चार्जेस और पूरे ढूंढने की कोशिश की है बाय ड्यू डिलिजेंस से कि भाई ओनर मिल जाए, अगर वो गुड्स पेरिशेबल नेचर का है, और व्हेन द लॉफुल चार्जेस ऑफ द फाइंडर इन दैट रेस्पेक्ट amount to 2/3 of its value, here the buyer gets a good title. Again, I will repeat here. A finder of the goods can sell the goods which he has found. He can sell the goods which he has found. If the owner of the goods cannot be found, goods का जो owner है मिला नहीं है, cannot be found, with the reasonable diligence, or if he refuses upon demand, अगर वो रिफ्यूज कर रहा है डिमांड के ऊपर भी, टू पे द लॉफुल चार्जेस ऑफ द फाइंडर, अगर वो फाइंडर लॉफुल चार्जेस नहीं दे रहा है, एंड द फाइंडर कैन सेल द गुड्स, सी द फाइंडर हियर कैन सेल द गुड्स इफ दे आर ऑफ पेरिशेबल नेचर, और when the lawful charges of the finder in respect of the things found amount to 2/3 of its value, here the buyer gets the good title. So buyer is getting here the good title again here. Ninth here exception is here sale by a pawnee. See, when P borrows rupees 500 from Q and keeps his pager as a security for payment of debts, such a transaction is called pledge. Here P is called pawner or pledger and Q is pawnee or pledgee. See, in this case, the ownership remains with the pawner. Okay? Hence, if the pawner makes default in the payment, अगर pawner default किया है payment में of the debt, the pawnee may sell the said goods. यहाँ पे जिस किसी ने प्लेज किया है, he can sell the goods because there is a default in the payment on giving the pawner a reasonable notice of the sale. पहले पॉनर को रीजनेबल नोटिस देना पड़ेगा यहाँ पे कि भाई आपने पैसा नहीं दिया है तो मैं आपका गुड्स बेच दूंगा, ये नोटिस देना पड़ेगा. इन दिस केस ऑल्सो अगर वो बेच दिया है, पॉनर ने बेच दिया है गुड्स को सामने वाला को, तो बायर विल गेट ए गुड टाइटल टू द गुड्स. हियर बायर विल गेट ए गुड टाइटल टू द गुड्स. ओके, सो 9th point here is exception is sale by a pawnee. So again we will see 10th point, sale by official receiver or assignee. In fact, these official receiver or assignees are not the owners of the goods, but still they can convey a better title to the buyer than they themselves possesses. Okay, this is a 10th exception. Again we will see the 11th exceptions. A holder in due course according to the provision of the Negotiable Instrument Act, a holder in due course gets a better title than what his endorsers had it. Means that a person who takes a negotiable instrument in good faith and for value becomes the owner if he takes it from a finder or a thief. So he gets a better title. Here we have completed here the exceptions to the rule of non-owner. See, transfer of title by non-owner we have already discussed here. We have discussed about the exceptions rule, and today we also discussed about the doctrine of caveat emptor. So in the next video we will be dealing rights of unpaid seller and remedial measures. See, what are the rights of unpaid seller and what are the remedies or what are the measures can be taken for these unpaid sellers. See, we will discuss here. And so next chapter is write-off unpaid seller and remedial measure. See you in the next video.